So having begun the recording, I think we can kick off the session today. So welcome everybody and thanks for joining us. I'm very happy to be reconvening today for this next session of the Tort Law and Social Equality Project speaker series as we continue building this community of scholars from around the world who are working at the novel intersection of tort law and social justice issues. Today, I'm excited to welcome Professor Sarah Swan from the Rutgers Law School to speak with us. Professor Swan, in many ways, embodies the spirit of this series, and that's not least because of her transnational pedigree, getting her initial law degree in Canada and now teaching in the United States, and I understand visiting Quebec in the near future as well, and coming back across the border. We're very excited to welcome her back to Canada, at least virtually today. Professor Swan has a very unique and interesting range of research interests. These include local governance law, discrimination law, family law, and private law, particularly the concept of third-party responsibility, where a person is held civilly liable for harms caused by another, such as where a parent is held liable for harm caused by a child. Just one very interesting example of this idea. One of her papers, called Plaintiff Cities, in the Vanderbilt Law Review, looks at the ability of municipalities to pursue private law claims to redress kinds of public wrongs like environmental harms. And I think the title of her talk today seems to be closely resemble the title of that Vanderbilt Law paper. Plaintiff Police is the title of the talk today. And as you can see from the slides here, it's forthcoming in the Yale Law Journal. So we are the first audience to have access and hear the talk based on this wonderful forthcoming paper in a high-profile outlet, and so we're very fortunate. Please welcome Professor Swan with me. She'll be speaking for about 45 minutes, after which we'll open up the floor for Q&A, and this is a very ripe paper for feedback, given that it's in the forthcoming stage. Thank you, Professor Swan, over to you.
Thanks so much. It's a pleasure to be here. I've really enjoyed watching the other speakers in this series, and so it's an honor to be included with them. We're going to start today with a quick overview of the whole project and flag some of the things that we're going to be talking about. The project is obviously about police as plaintiffs. So usually we talk about the police as defendants. We see, headlines where cities are entering into big settlements because someone has sued the police for an issue of police brutality. But in recent years, particularly as the Black Lives Matter movement has gained traction, police officers have increasingly been acting as plaintiffs, both by bringing the first claim in a legal proceeding and by initiating counterclaims after they've been sued. And they sue for all sorts of things. So they sue for things coming out of protests, they sue for defamation, they sue for privacy harms, they sue for physical injuries, they sue for emotional injuries. And our first step in our journey is going to be exploring what some of those cases actually look like. In the paper, I argue that these lawsuits are really important, both practically for people who are getting sued and more broadly as a political matter. And I argue that they bring into tension really core fundamental principles of justice. So on the one hand, we have the value of open courts. We have the right to petition for redress of grievances. We want people who are injured by wrongful means to be able to get redress for those harms. We want compensation for injured people. We want deterrence for injurers. On the other hand, though, these suits actually inflict their own harms. First, there's a huge power imbalance between the police and those that are policed, and these claims add to that. Second, there's another asymmetry in that it's really easy for the police to successfully sue people, but it's very difficult for people to successfully sue the police for a whole host of reasons I'll unpack as we go through. Thirdly, this plaintiff police litigation chills speech and political participation. In fact, I argue that these lawsuits have their own democratic harm because their impact on political participation is so significant. Sociological evidence tells us that negative encounters with police hugely impact things like voting and actually all forms of civil engagement. So they cause people to withdraw from their political communities when they have these negative encounters. These harms are so great that I'll argue at our second to last stop, we should actually limit the availability of these suits. And I suggest that tools that we already have, like the professional rescuers doctrine in common law and anti-SLAPP legislation from the legislative side of things, can be helpful as we start thinking about how we might do that. Finally, as we wrap up, I'm going to consider what all of this means in terms of the relationship between these lawsuits and the politics of litigation more broadly. Usually we think of litigation expansions as things that progressives or Democrats want, and we think of litigation contractions as being associated with a more conservative or Republican view. But actually, as we see reflected in this project, the landscape is becoming a lot more complicated and things are really shifting politically on that front. So we'll close out by talking a little bit about that. Let's begin with the plaintiff police landscape and talk about what these claims look like on the ground. I'll start with a point of clarification. Police officers bring all sorts of lawsuits for all sorts of reasons. They sue their employers, the city usually, for job-related issues. They sue other drivers. They sue businesses for non-job related accidents. In other words, they sue for a lot of the things that non-police people sue for. And this project is not about those claims. This project is about when police sue people that they are policing for harms that arise in the course of policing. And it's useful to think of these claims as falling into four main buckets. First, we have claims connected to protests, so policing protest claims. We have claims for defamation and privacy, usually related to complaints of police misconduct. So someone will engage in a complaint publicly or sort of talk about misconduct that's occurred, and the police will respond with a defamation or privacy claim against them. We also have plaintiff police litigation just for direct physical injuries incurred while policing, and we have plaintiff police litigation for emotional harms. Starting with the protest, we see a lot of this in the media. And that's a picture of one of the major litigative parties in a major suit that's happening in the States right now. So the Black Lives Matter movement, which started in 2013, is now recognized as the largest protest movement in American history. Tens of millions of people took to the streets to respond to widespread practices of violence and brutality against citizens, mostly Black people, hence the slogan. So the protests were predominantly peaceful, but were met sometimes with really aggressive police tactics. So protesters were kettled, they were pepper sprayed. Cities like New York have been entering into multi-million-dollar settlements for what is now acknowledged to be sort of an overly aggressive police response to what was happening. The position of police union leaders, though, is that it was actually the police who were deeply harmed by these protests, and it's the police who got scapegoated by these city leaders entering into these settlements. Union leaders publicly announced that they were going to encourage officers to turn to civil litigation as a response. So, for example, one leader told reporters they're going to start suing violent rioters and looters, and these lawsuits are specifically not about the money. They're instead about sending a message. And that message is, we're tired of being abused and assaulted, and if the looters are going to try to interfere with us and make our lives miserable, we're going to make their lives miserable. Following this announcement, one New York City detective sued a 19-year-old protester for assault, saying that he was injured when the teenager resisted arrest, and another sued a protester for the tort of intentional infliction of emotional distress after that protester hurled a slew of racist anti-Asian insults at that officer. Two police officers in Baton Rouge, Louisiana, also initiated lawsuits arising out of these Black Lives Matter protests. In one suit, an officer sued civil rights activist DeRay McKesson, that's who's featured in that slide there, after suffering injuries from a projectile thrown during a protest. The officer suing as a John Doe, which is really interesting if you follow Eugene Volok's work, because of alleged safety fears, sued in negligence, alleging that by arranging the protest as he did, McKesson knew or should have known that the police would be forced to respond to the demonstration would turn violent, and someone might be injured as a result. The Fifth Circuit ultimately held that this claim stated a valid cause of action, thereby creating a new negligent protest cause of action for officers. And that case is now, there's a writ pending at the Supreme Court of the United States. It looks like it's going to be taken up, but we'll see what happens on that front. In the other suit, a sheriff's deputy shot a gunman a week after the same protests and sued McKesson and other leaders in the Black Lives Matter movement. In that shooting, a gunman had killed 3 Baton Rouge officers and left the plaintiff police officer in a vegetative state for more than 3 months with significant brain trauma. The plaintiff alleged that McKesson and others incited that gunman's violence and were responsible for his deadly attack because they knew or should have known that violently mentally disturbed persons would be aroused by their call to violence and retribution to police for the deaths of Black men. That case ended up getting dismissed by the Fifth Circuit on the basis that it stated no plausible claim. An additional area of plaintiff police protest litigation arose in response to the insurrection of January 6, 2021. So close to 140 police officers were injured when following the followers of former President Trump stormed that Capitol building and attempted to disrupt that transfer of power from President Trump to incoming President Joe Biden. That insurrection led to a number of legal responses. It led to a congressional inquiry. It led to the largest criminal investigation in the history of the Department of Justice. It led to a number of civil lawsuits filed by various organizations like the NAACP, and multiple individual officers brought their own suits as well, generally alleging that former President Trump incited that violence and bore responsibility for those injuries. So a lot of activity happening in that protest litigation area still, and we see an explicit strategy from police leaders to sue protesters. We also have a category of plaintiff police claims sounding in defamation or privacy torts, often as a result of a complaint levied against an officer. Interestingly, the landmark case which first defined the relationship between defamation and the First Amendment, New York Times versus Sullivan, was itself a plaintiff police suit. In that case, a group of civil rights activists in the 1960s had purchased a full-page ad in the New York Times, which you see featured there, excoriating the police chief and other police officers in Montgomery, Alabama for racist misconduct. Some of those claims had minor factual inaccuracies, and the police commissioner brought suit in libel. At the time, libel really functioned as a strict liability tort. So sort of any factual falsehood, however innocently made, could attract liability. But the court took the opportunity in this case to use the First Amendment to readjust the parameters of that defamation tort and to say that public officials, a group that includes virtually all police officers, would need to show actual malice in order to have a successful defamation claim. So they are going to have to show that the statement was made with knowing falsity or recklessness in order to attract liability. That's a purportedly high standard, but police officers still quite frequently bring defamation claims after individuals complain about their behavior. My favorite example is a current lawsuit that a number of police officers have brought against rap artist Afroman, who's most famous for his 2000 hit, Because I Got High. Officers sued him after he featured home security footage of an unsuccessful raid they made on his house in his music video for a song entitled, Will You Help Me Repair My Door? Because the door was broken during that raid. He made posts about the raid to social media, and he also created merchandise like TV t-shirts featuring still photos of the police during that raid. And I'm just going to try to play you a little bit of that video so you can see the source of the complaint. There we go. And whoops, stop. Here's an example of one of the merchandise t-shirts that was created. So you can see the three police officers in the background. There's a moment in the video where they become really interested in a lemon pound cake that's on his counter. And so he makes fun of their desires for treats. There's also a number of cases where officers sue individuals who complain that the officer is racist or behaved otherwise inappropriately. So a number of cases also relate to unfavorable media postings, and police union leaders have also indicated that they intend to encourage officers to sue, and these claims too are part of a broader legal strategy. So one leader told reporters police officers have been targeted for harassment, false accusations, and doxing by Antifa and other similar Marxist organizations assisted by left-wing media. And the union must respond when its members are defamed or harassed or put in danger by those that wish to do us harm. In his words, slandering our members deserves a response, and civil litigation is going to be that response. Another category of plaintiff police claims are for physical injuries. So as one example here, after 3 police officers shot and killed Breonna Taylor in her apartment when they implemented an improvidently granted, as we now know, no-knock warrant, her boyfriend, Kenneth Walker, who was also present but survived, sued. One of the officers, Jonathan Mattingly, then brought his own claim in the form of a countersuit and argued that when Walker fired at them, these unidentified police officers assailing the apartment in the middle of the night, and was struck in the thigh by one of Walker's bullets, he suffered battery and assault and intentional infliction of emotional distress. And the officer claimed that he should be entitled to compensatory damages for medical treatment, trauma, physical pain, and mental anguish he experienced as a result of the night Ms. Taylor died. One attorney offering public comment noted that counterclaims in general are not unusual. It's not strange to see them brought. But the circumstances of a police officer suing someone after police have killed their romantic partner were questionable. So he publicly described the countersuit against his client as the latest in a cycle of police aggression, deflection of responsibility, and obstruction of facts in what is an obvious cover-up, and made a comment about how you'd think executing Walker's girlfriend and framing him for a crime in order to cover that up would be enough, but this baseless attempt to further victimize and harass his client indicates otherwise. Officer Mattingly, then responded by suing that attorney and the firm that he worked for, back to our defamation claims, in addition to this ongoing counterclaim for these physical injuries. In another case, when an officer was shot and killed by a robbery suspect at Temple University in Philadelphia, his family sued the 18-year-old shooter and the shooter's family, including the mother, father, and mother's boyfriend, alleging that they were aware of the shooter's mental instability and interest in firearms before the incident. The shooter was charged with murder of a law enforcement officer and other related offenses as well. Other plaintiff police suits for physical injury look pretty similar to our average negligence cases we would expect to see in non-police contexts. So things like premises liability or vehicular accidents, but they arise in circumstances of policing duties being performed. So for instance, a police officer sued a family after she slipped on water and injured her knee in the course of a call rescuing a 1-year-old boy who had fallen into the family swimming pool. So he survived a drowning, but suffered a catastrophic brain injury. And the officer sued the family for leaving a puddle of water on the floor during the rescue, which caused her to slip. Finally, we have claims that sound mainly an emotional injury, including being forced to inflict injuries on others. So in one case in Chicago, a white police officer sued after he shot and killed a Black 19-year-old mentally ill person and his neighbor. The officer was responding to a domestic disturbance call, describing the teenager as threatening his father and wielding a baseball bat. After the killings, that father sued the city for wrongful death, wrongful arrest, excessive use of force, and not providing prompt medical attention to his son. The officer countersued. He asked for more than $10 million from the teenager's estate for assault and affliction of emotional distress. According to the complaint, the 19-year-old knew that his actions were extreme and outrageous, and that his conduct was atrocious and utterly intolerable in a civilized community. And the complaint goes on to say that by forcing the officer to end the teenager's life and the innocent bystander neighbor's life, the 19-year-old caused the officer to suffer extreme emotional trauma. In commentary on the case, one legal expert noted that, again, counterclaims are common, but a police officer suing someone that he's killed was both unusual and detrimental to public police relations. So a newspaper article noted that, in their words, blaming a mentally troubled young man that the officer shot is unlikely to win him many defenders. And social media responded with shock at the suit, disturbed by the optics of an officer demanding $10 million from the family of a college student killed by a police bullet. The victim's father called the countersuit a new low, even for the Chicago Police Department. And if you know anything about the history of the Chicago Police Department, that is already very low, noting first you shoot them, then you sue them. The lawyer for the police officer, on the other hand, said it's important in an atmosphere charged by police shootings to send a message: police are not targets for assault and they suffer damage like anybody else. Officers also sue when they witness traumatic events, just generally. So as one example, in a small town, West Deer, an officer who witnessed a man's horrifically gruesome prolonged death by electrocution from a downed utility wire sued the power company for negligent infliction of emotional distress and nuisance, contending that their negligence left him traumatized. Okay, so that is a quick and dirty overview of the plaintiff police landscape, what these cases look like. Let's put that in a little bit of context now. Why are we seeing these suits? Why are we seeing these suits now? Really, I see it as three trends feeding into this. First, and I won't spend a lot of time on this point as there's a large literature readily available here, the push for equal rights in the face of rampant practices of white supremacy has been a defining issue of this millennium. The role of police in upholding these systems of white supremacy is well documented and well researched. Many of these plaintiff police cases, particularly coming out of these Black Lives Matter movement protests, are quite obviously all about race and white supremacy. And so these plaintiff police claims are being used to uphold an existing unequal status quo and really stifle any dissent pushing for a new or more equitable racial order. Second, there's really a broader law enforcement trend of turning to civil remedies alongside criminal ones. And that's been in play for quite a while. So both policymakers and police departments have increasingly been using civil tools as a means of achieving criminal law enforcement goals. So for instance, combating gang activity has long used the practice of civil injunctions, suing the gangs to get a civil injunction to stop them from gathering on street corners or from being present within specific areas. Gained a lot of traction in the early 2000s. It's since less so because of its constitutional problems. Another example of civil and criminal lines blurring in this law enforcement context would be crime-free ordinances and nuisance abatement. So we've seen a crime-free, what's called a crime-free program, which is developed and distributed by a former police officer in Mesa, Arizona, which involves using the civil tool of eviction to achieve crime control ends. So when a renter or someone in a renter's family is arrested or accused of an offense, the crime-free program mandates the eviction of that family. Nuisance abatement functions in a similar way. So police will say a cite a place as a scene of illegal activity, and they will bring civil legal proceedings in nuisance abatement to get it dealt with through that forum. This has actually carried over into the street. So Milwaukee police have begun using civil public nuisance to sue reckless drivers. In one lawsuit, police alleged a reckless driver constituted a public nuisance, arguing his ongoing negligent and reckless driving affects the quality of life and safety of our community. They warned 20 other people that they were going to face similar lawsuits, noting that they had issued numerous tickets to those people that weren't achieving their deterrence goal. In the words of the Milwaukee police chief, the civil litigation approach against egregious reckless drivers is intended to send a clear message to all the chronic reckless drivers in Milwaukee that we take the safety of everyone on the roadways very seriously. Given this increasingly blurry line between the civil and the criminal, and the reality that police officers, as criminal law enforcement actors, are often themselves on the receiving end of civil litigation, it's not surprising that these official enforcers of the criminal law would see potential in becoming enforcers of the other civil law as well. Both civil and criminal systems are increasingly embedded with each other and already comfortable with employing these civil law remedies and these tools in the context of criminal law enforcement. We see police officers increasingly turn to private litigation to pursue tort claims against individuals as well. Third, and finally, in our trends that help feed into these plaintiff police lawsuits, we see a broader trend of role switching between plaintiffs and defendants. And we see this occurring in multiple contexts. So sophisticated corporate parties have developed strategies to manipulate whether they're going to be a plaintiff or a defendant in a particular suit. One example would be insurers. They can easily choose to litigate as either a defendant or a plaintiff. If they deny coverage, they're going to be a defendant. If they grant coverage, they can subrogate the claim and sue as a plaintiff against the injurer. Banks have a similar capacity. If someone owes them a debt, the bank can sue to recover it, or they can start garnishing wages and accounts and wait to be sued and come in as the defendant at that point. And they make that decision based on what sort of procedural benefits the different positionalities are going to afford. We even see this a little bit in the mass tort context. So after a consortium of California city and county plaintiffs won a historic $1.15 billion award against lead paint companies, those lead paint company defendants threatened to turn around and sue individual property owners, become plaintiffs, and allege that those owners should have made efforts to remediate their own properties. So as one legal scholar put it, they turned around and said recipients of the damages should be disqualified because they're to blame, and this threat to turn the tables was enough to whittle that $1.15 billion award down to a $350 million settlement. The traditional binary between plaintiffs and defendants has further broken down in the wake of the Me Too movement. So the Me Too movement prompted many victims of sexual assault and abuse to bring civil suits for remedy, but those lawsuits then spawned a series of retaliatory defamation suits against the victim accusers. So the person accused of sexual violence instead became the plaintiff in these defamation suits. This flip from defendant to plaintiff corresponds with a common strategy used to rebuff claims of sexual abuse. So psychologist Jennifer Fried has shown that persons accused of sexual assault often resort to a technique known as DARVO. It's an acronym that stands for deny, attack, and reverse victim and offender. Many plaintiff police claims utilize this strategy as well. So through a defamation suit against someone who has complained of police misconduct, for example, the plaintiff officer denies the initial conduct, challenges the person making the complaint, and repositions themselves as the wronged party and the inappropriately policed person as the offender. That's actually probably even easier to do in the plaintiff police conduct because the person complaining of police misconduct will often have already been suspected of some sort of underlying offense in the first place. So that eases the path for that here. The connections between the flood of defamation claims arising in that Me Too context and this current plaintiff police litigation trend are not subtle. So in an article about the case of the officer suing the family of the mentally ill teenager, Professor Paul Butler noted that the case reminded him of Bill Cosby suing his accusers for defamation. So it's a pretty clear parallel. Okay, so that's what it looks like. That's sort of the trend lines that are feeding into this litigation trend. That's what plaintiffs' police suits look like. Why might it be a good idea to have these suits? Why might we want them? What arguments support police bringing forward this kind of litigation? Well, most of these are actually pretty obvious, right? Giving people access to courts is something we value. People harmed by the wrongs of others should get compensated. We want to deter harms from happening. And it's not immediately clear why we would deny the members of one profession something that we grant to others. In terms of access to courts, we have all sorts of judicial language about how important this is, going all the way back to Marbury versus Madison, that access to civil redress strikes at the very essence of civil liberty. We see this in state constitutions. Almost 40 states have open courts or right to remedy provisions in their constitutions, granting the right of the citizenry to access the courts. Arizona, for instance, has an even stronger provision declaring the right of action to recover damages for injuries shall never be abrogated, and the amount recovered shall not be subject to a statutory limitation. Kentucky has a similar provision. Virtually every state has at least one explicit guarantee of providing a right to jury trial in civil cases. So we see huge value of access to justice and access to courts in those state constitutions. We also have a federal constitutional right to petition, reflecting the centrality of accessing civil redress in that context. So the petition clause of the First Amendment grants people a right to petition the government for a redress of grievances. It's part of the core political rights that the federal Constitution protects. We often think of this as just applying to the legislative branch of government, but there are very strong arguments that this clause encompasses a guaranteed right to judicial remedies as well. Another way we can see the value of access to courts is that in the United States, the vast majority of jurisdictions reject the loser pay rule that governs in most other Anglo-American systems. So under loser pay rules, if you sue and you lose, you're going to have to pay the other side's costs, which is going to make you think long and hard about bringing forward a lawsuit. But in most states in the United States, each party is going to bear their own legal costs. And so obviously the idea is that's going to encourage the filing of lawsuits, and that's something that we want to see happen. A main reason plaintiffs attempt to obtain civil redress in the courts is to get compensation, right? So we think it's important when people are injured that they're able to get compensation from those that injure them, and the state has a important role and indeed a duty, some would argue, to allow people to access this compensation from those that injure them. In this plaintiff police context, police officers experience injuries and sometimes even death on the job. These, like anybody else's injuries, these injuries permeate through all aspects of life. They impact the ability to work, to engage in recreational activities, to participate in family life, to just enjoy life. We see mental health consequences stemming from receiving physical injuries, things like depression, increased weight issues, substance abuse, and both corrective justice and common sense notions of fairness suggest that a wrongdoer should compensate the person harmed by these activities who suffers these negative repercussions as a result of their actions. We also have deterrence as a core premise of tort law. So we have the idea that civil liability is going to create deterrence and make it less likely for actors to engage in similar behavior. Obviously, we don't want people assaulting or deliberately harming police officers. That's something we do want to discourage. And the potential of hefty damage awards through civil litigation can help us do that. Finally, in addition to those arguments supporting plaintiff police litigation, you could also argue that police officers should sort of be the most entitled of anyone to bring litigation, since their job is understood to entail a high degree of risk and to be necessary for social functioning. So on this argument, we have a general rule in tort law, a duty of reasonable care to avoid physical harm to others, and there's no reason to make this sort of exception or carve out for police officers. On the other hand, though, and here is really the heart of the article, what we can sort of at first blush immediately see reasons why we might want plaintiff police litigation, because it fits in with all of those access to justice values that we have. When we dig a little deeper, we can see that actually these claims inflict really significant harms. And so we're going to unpack what these suits do and what harms they bring. The first problem is that these suits add to an already existing power asymmetry between the police and the police. So police officers are a unique kind of public official. They hold a public office, meaning that they're supposed to be furthering an important and legitimate function of government, and they receive a number of special rights, privileges, and powers to do that. So for police officers, they're armed agents of the state. They have a near monopoly on legitimate use of force. They have unparalleled powers over the average citizen. When they show up to do something like prepare a car accident report or do a welfare check or resolve a street dispute, they're at the same time legally authorized to kill you if they deem that appropriate. And that makes them really different from other holders of public offices. We now know that that power is unfortunately often abused, and police officers have many ways of letting people know that complaining about those abuses is only going to make things worse. So if an officer uses excessive force during an arrest and an individual indicates that they might make a formal complaint, that officer might respond by criminally charging that individual with what's been referred to as the trilogy, the 3 offenses of disorderly conduct, resisting arrest, and assaulting an officer. Once those are sort of threatened, the officer might say they're going to drop those in exchange for the individual agreeing not to make a complaint about them. And we see this on the broader litigative scale when plaintiffs who are harmed by police misconduct bring litigation, and DAs will often say, okay, well, we'll dismiss the criminal charges if you agree to dismiss your civil rights complaint for police brutality. And the Supreme Court has said that those deals are fine, for the record. When police engage in misconduct in a police-civilian encounter, so the deck is already heavily weighted in that officer's favor. The officer gets to decide whether force is appropriate to use, and we see a lot of deference from courts about the decisions that they make. When we let officers civilly sue individuals, we're just adding to that already overstacked arsenal and creating even more imbalance between the powers that each party holds. Second problem is an accountability mismatch. So again, it's pretty easy for police to sue people. They don't face a lot of doctrinal or special doctrinal hurdles. Whereas when individuals try to sue the police for misconduct, it's so difficult. It's been described as virtually impossible by a lot of scholars. It's rare for people to succeed on their suits, even though cities settle these claims. If claims go to trial, it's really an uphill battle for a plaintiff to succeed against a police officer. In addition to civil litigation against police officers, there's other potential forms of getting accountability, none of which work well, right? So one is bringing formal complaints against the police, but all of the research into those processes say that they're not transparent and they don't usually result in any sort of censure. Usually the department agrees that the police officer behavior was fine. So in a study of 600 citizen complaints made about police abuse in Los Angeles, one study said not one was sustained by the department. So that's an uphill battle. Getting redress through the criminal law against police officers has also been shown to be an uphill battle. Very rare that we see criminal liability. It's starting to happen a little bit more now, but still an uphill battle. In that civil litigation context, the reasons why it's so hard for people to sue police officers include a lot of doctrinal and procedural hurdles and practical hurdles. So the first sort of one is the majority of criminal defendants are poor. So the people having those encounters with police are often not well resourced, and it's difficult to find a lawyer to bring forward that kind of civil suit. And then in the United States, we have the doctrine of qualified immunity, which has really stunted the potential of a constitutional remedies to serve as meaningful forms of redress. So the government officials performing discretionary functions are shielded from liability insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. And what that means on the ground is that only officers who are plainly incompetent or who knowingly violate the law are going to be held liable. So when we look at sort of how often people are successful in these claims, it's low. Third reason, justification against these plaintiff police litigations is sort of self-evident. Obviously, it's going to chill free speech and political conduct if you know that that's, like in the protest context, if you know that that's going to result in a lawsuit against you, you're going to be very much less likely to make the complaints. A stark example of how lawsuits can impact voicing complaints about misconduct happened in Seattle in the mid-1990s. The Police Officers Guild there sued 6 separate individuals for defamation after they had filed complaints of misconduct that the internal investigation section did not uphold. And in the 6 months following that lawsuit retaliation, there was a drop of almost 75% in citizen complaints. So you can see that sort of impact happening. Finally, there's a democratic harm. So when people talk about the police in America, what they're actually talking about is local police officers. So of the 850,000 total law enforcement officers, about 650 of those are local government police. So police are really sort of the face of the city. They're representing the city. They're the embodiment of it. When police citizen encounters go bad, people interpret that as meaning that they have a fractured relationship with the state. And so what we see is it really creates political withdrawal. So there's a growing body of research that illuminates how these police encounters reverberate throughout civic life in general. One study looked at a novel measure of local citizen engagement, 311 calls to a city helpline, and more than 1 million police stops, and concluded that the character of police contact was a really important factor in the overall amount and quality of community engagement and democratic participation. They found that the character of policing had significant consequences, and that when policing was experienced by the citizenry as fair and responsive, those characterizations were generalized to the political system as a whole, and they encouraged civic engagement. When residents saw police as hostile, invasive, untrustworthy, that became their dominant view of the state and their political community, and that bred political alienation, distrust, and withdrawal. So citizens who have negative experiences with the police are less likely to vote. They're less likely to call local governments for assistance via mechanisms like these 311 lines. They're more likely to experience a sense of alienation and exclusion from the body politic. And if we look at what we know about voting, the most disruptive forms of criminal legal contact, like arrest and incarceration, drastically discourage people from voting, but even minor, what we would think of sort of as not significant forms of contact with the police, like a misdemeanor charge or a day or less in jail, also measurably decrease the potential of voting. And these are especially pronounced for Black arrestees. So white people sent to jail voted a bit less often, but this study found that Black people turned dramatically away from voting, with their participation following by approximately half after these negative encounters. So even short inappropriate stops reduce political participation, rendering citizens less likely to engage with their local government. When you have a negative encounter with a police officer, and that police officer then goes on to sue you, that problem of political withdrawal is exacerbated. And that democratic injury of having that negative encounter is exacerbated as well. So given these harms in sort of the last couple minutes, I argue that we should limit plaintiff police suits. And I talk about a couple of ways that we could begin doing that. One, we have a professional rescuers doctrine in our common law. And that's what that rule says, stated up there on the slide. It's going to bar injured public safety responders from maintaining a negligence action against a tortfeasor whose alleged malfeasance is responsible for bringing the officer to the scene of a fire, crime, or other emergency where they're injured. So under this rule, if it applied, a police officer injured by something like slipping on a puddle while trying to rescue a drowning child would not be able to sue that child's families for those injuries, for that knee injury. The professional rescue doctrine has been part of the common law for over 100 years, but there is currently a movement to scale it back. So we see a lot of states either using a series of exceptions to limit its application, or some that haven't yet adopted it, declining to adopt it. I argue that that trend line is in the wrong direction, at least as it relates to police officers. So other safety institutions like fire officials might have a different relationship with the public that they serve. So one person joked in an online forum, for example, that there's a reason no one's ever made a song called F the Fire Department. But because of the unique factors involved in the plaintiff police context, police officers at the least should remain subject to the rule. And indeed, we could, in some instances, see it expand. Second tool that we have already here is anti-SLAPP legislation. So SLAPP stands for Strategic Lawsuit Against Public Participation. Anti-SLAPP legislation is meant to help avoid or deter those lawsuits. So the typical SLAPP suit would be like a activist complaining about an oil company, and that oil company then suing that activist for something like defamation. So that's what anti-SLAPP legislation is trying to have those kinds of lawsuits not happen. Notably, the tsunami of defamation claims brought against complainants arising out of that Me Too movement actually prompted a lot of action in this anti-SLAPP world. So there was approximately 20 states that already had anti-SLAPP. In the post-Me Too era, we saw 12 more join, and other states that had sort of less robust versions of anti-SLAPP legislation have buffed them up. What this legislation does is it provides procedural mechanisms for defendants in these cases to get those cases out of court quickly. It lets you bring an anti-SLAPP motion. If you win your anti-SLAPP motion, it lets you get costs for the harms that you've suffered from that lawsuit being brought against you, and it lets you appeal quickly if that anti-SLAPP motion goes against you. So these are helpful, but obviously don't fix the initial harm of having that suit brought against you. Finally, I argue that we can achieve the goals of compensation and deterrence through other means. So for compensation, obviously the other alternative would be workers' compensation. In many states, workers' compensation statutes already apply to police officers, and a handful of states have used separate administrative regimes that just apply to police officers. There is an argument that you still get less money from workers' comp than you would get from litigation. But we need to remember the reality is that most people who are in those police citizen encounters are not going to have significant financial assets from which to recover any judgment. So the average white American, for example, has approximately $80,000 in savings, and the average Black American has $13,000, amounts which make it difficult to really see any meaningful recovery from. So even though you might technically get less on, it looks like less on paper under workers' comp, it is certain money, as opposed to litigation where even if you have a judgment, it's not clear that that's going to be enforced in a way that actually gets you that compensation. Second thing is we do need deterrence, but we get that, I argue, from the criminal law. And when we are in the world of police officers, we have heightened criminal law protections that apply. So if we have, if we think of sort of a general assault, one person versus one person, that's going to be a misdemeanor, and that's going to often result in a maximum possible sentence of a year in prison. Assaulting a police officer, on the other hand, is a particularly egregious offense. It's understood as a violent felony, and it's going to get you a mandatory sentence of minimum 2 years imprisonment. And we see a similar distinction in homicide. It's going to make you death penalty eligible if you kill a police officer, or it's going to put you in jail for life. There's a new bill in Iowa that's going to require people who attempt to kill police officers to serve 100% of their sentences with no ability to earn time off for good behavior, which is really significant. I also argue that actually one of the, in terms of dominant theories of criminal law, the idea is that it's not the severity of the punishment that determines whether you're going to engage in the behavior. It's actually the certainty of getting caught. And if you are having an encounter with a police officer, the certainty of you getting caught for any wrongdoing seems to be as high as it possibly could be. And it's difficult to imagine a world where someone is not deterred by that criminal penalty attaching and yet will somehow be deterred by some hypothetical civil judgment against them in the future. I'm out of time, so I won't talk about the politics of litigation now, and I'll just turn it into the Q&A.
Thank you so much, Professor Swan. Maybe we'll get to that in the Q&A, those political questions. But thanks for bringing such a wide-ranging wealth of knowledge to bear on this talk from very different kind of corners of the legal system, even. So I'll open it up now for question and answer. So to get on the queue, I'll keep a queue. To get on the queue, just write me in the chat or use the hand raise function on Zoom. We already have one person, Professor Ellen Bublik, to get us started.
Thank you so much for this presentation and the voicing some of the concerns about the liability. I sort of come at this from a different angle, which is that in the US, we're looking at more liability with fewer exceptions from the norm of reasonable care, both with respect to people injured by police and with respect to police suits. And I guess I have a couple questions for you. The first of which is, I feel like you're not really fully taking into account the legitimacy of police interests. And in the paper, you know, in some places you have really even sort of a mocking tone about, you know, how ridiculous some of these suits are. But if you know, really even Doe versus McKesson, look at how devastating the physical injury there is, I think it would be more helpful to take that in. And some of the factual things about it's really easy for police to sue. I think there's a lot of exaggerations there that you might want to correct. And I guess, so my first question is, can you really, you know, take in the full legitimacy of the claim and then make this argument that you're making and explain if these are really crazy claims, why can't we count on courts to do their job? Are there instances where going through the whole process, the courts aren't doing their job? Because I think sometimes there's like more of a claim than you may be allowing. And I guess my second question would be, you know, in part of the paper, I sort of hear you arguing that, you know, we ought to take away police suits, even for intentional injuries, even for being shot at and things like that, because we want to promote social values like people in jail voting and so on. And I think, isn't that sort of an exploitation of the individual's claims, and do police still have some interest? And in some of the cases, like where you're talking about, you know, the crazy slipping on a puddle type of case, seems to me just to be about, not about how much income that person has, but just about homeowners' liability insurance, and can police also collect on that kind of thing?
Thank you. So I don't mean to make light of any of the injuries that police officers suffer. They obviously do suffer injuries, and some of those injuries are terrible. And I think in like anybody else, if you're wrongfully injured, you should get compensation. And I think if you're performing a public job, you should get compensated. I just think we have other mechanisms that we can use for that compensation that don't have the same downsides as this plaintiff police litigation does. I'm going to push back on the assertion that it is easier for people to sue the police than I make out. I feel like there is really significant scholarship from people like Joanna Schwartz that have really granularly looked at what kinds of procedural and doctrinal hurdles people who are suing the police face. And it's sort of well recognized that there is a gross imbalance in how difficult that is. And so I feel like that is well supported in the piece. So I definitely support compensation for police officers, but I do think there is a enormous asymmetry between the difficulties that a police officer has in suing an individual, where there's really no special doctrinal hurdles they have to jump over, except for potentially that higher threshold in defamation, versus a civilian trying to assert a claim against a police officer where there's dozens, literally dozens of procedural and doctrinal hurdles that they're going to have to account for. In terms of sort of the homeowner's liability question, again, it opens up a slew of political harms that a bucket that we don't need to open if we have adequate compensation through administrative mechanisms. So I see it as having a lot of downsides and not a lot of upsides if we can get that compensation and that deterrence, right? We have very significant criminal penalties that apply to intentional wrongdoing towards police officers. We put our highest criminal penalties to those. And so it's unclear to me how a civil lawsuit could possibly add to the deterrent effect that those very intense criminal punishments are meant to have.
Okay, thank you. Next on the queue, I have Sam Beswick, Professor Sam Beswick.
Thanks, Anthony. Thanks, Sarah. This is a really great presentation and very thorough. I haven't
substitute for a company background check. This background can also be compared to the furniture because it involves its own
it looks as though maybe Egypt, Watson, you have you can mute your mic.
You might be able to do it, Anthony.
Yeah.
Sorry. Yeah. I really enjoyed the presentation. I haven't actually seen the paper myself, but I was frantically Googling it, but I didn't quite come across. But I'll be interested to read it when I do. And it was, it's very thorough. So that I agree with you that, and I'm kind of building on Ellen's question again, I guess. And hi, Ellen. The thing that strikes me with these cases is that inequality feature. As you were kind of describing a lot of these cases of people intentionally injuring police officers or things, it doesn't strike me as inherently problematic that those officers should be able to sue for torts that are committed on them. The problem is it doesn't work in reverse, as you say. Qualified immunities, statutory immunities, official immunities, everything else operates to prevent citizens from suing officers in a way that it doesn't prevent officers from suing citizens. And so that's where I see, for me at least, the heart of the problem. In Canada, my feeling, I don't know, Zoe might correct me, but my feeling would be we would have less concern about these sorts of suits theoretically because we place more weight on the normative equality of police officers with ordinary people, meaning in theory, it's easier to sue a police officer as an ordinary person. And so why should we be concerned if the officer could sue somebody who batters them? And we have cases where we have that situation where, for instance, one of the famous cases is where a woman scratches an officer for grabbing her arm, and the officer prosecutes, and she pleads self-defense and succeeds on self-defense. And so, I suppose to wind up my ramble, I suppose when you're talking about, say, the Breonna Taylor boyfriend case, my concern in a case like that would be, in theory, maybe it's all right to be able to bring a suit, but of course the boyfriend should have a pretty strong argument in self-defense. My concern would be that officer immunities would essentially work to, or my question for you really would be, in a case like that, would there be a strong argument for self-defense? Would the officer also be able to benefit from kind of a variation of the immunities that would otherwise be brought in order to negate the citizen defenses in these cases. Because if that's the case, it's even more problematic, and it comes down to should we be treating officers as just equal citizens, or should we be treating officers special? And if we're treating them special in one context, then we need to be, as you say, treating them special in the other context, and in the other context that means making it more difficult for them to sue.
A large part of what I'm saying is that if we have all of these special privileges that we give to these holders of public offices, that these particular holders of public office that apply when they are on one side of the V, it's not fair to just say, but nothing special applies to you. You cannot be sued effectively, but you can sue till the cows come home. There's something, and for someone who's already or an institution that's already so empowered to also have that power, seems to me to serve little purpose, but to do a lot of harm.
If that suffices for Sam, then I'll add myself to the queue before moving on, Professor Swan. So I had a question about the sort of formal equality and I guess substantive equality distinction that I think your argument relies on, and kind of bringing to bear some of the literature on discrimination theory here. So it seems like one of the arguments in favor of plaintiff police is a kind of principle of formal equality, and your response is, look at the substantive inequality between these parties that undermines that formal equality claim. I think that's true, depending on how we think about the relevant form of inequality here. So it seems clear that all the time there might be physical imbalance of power, there might be a political imbalance of power, and there might be kind of a resource-based imbalance of power. But I think so. One of the examples that you mentioned was a case where a person utters a racial slur towards the police officer. And I think one thing that sort of illustrates is that forms of racialized power, gendered power, can be wielded in a kind of symmetrical dimension in this way. So they can go on the part of the police towards the citizen and the other way around. And the reason why so Deborah Hellman has this kind of very influential expressivist account of what makes discrimination morally wrong. And on her account, one of the conditions for wrongful discrimination is like wielding power. And so, one of the objections is that can't you see, for example, a student in a university setting abusing some kind of racialized power, say towards a professor, where we ordinarily think of that involving a different sort of authority structure. So I guess like you could see where the objection is, and maybe the way of putting it is to say, in cases where that kind of substantive equality goes in the opposite direction, not kind of wielded or abused by the officer, should that be an exception to the general kind of asymmetry that you're pointing out? In particular, because it seems like allowing a suit, let's say for intentional infliction of mental distress against the officer or by the officer for a racial slur, wouldn't that promote some of the purposes that you see of kind of having this bar?
Sort of the scheme of things, right? If we take the police part out of it and just say someone is suing someone else for yelling racist anti-Asian insults at them, Tort is not going to care about that, right? And that's not a great thing, right? But in general, Tort's response to racial insults is nothing, right? And even though sometimes people bring these claims, usually under intentional infliction of emotional distress, they don't do well, right? And so that claim would very likely not be successful outside of the police context. It's also not likely to be successful in the police context. And it's what you can sort of infer from that union leaders discussion is that it's actually not important whether it's successful, because the point is just to deter. And in that particular instance, we might want to deter racist, anti-Asian insults in any context. But there is a lot of cost involved with that. And I think also in response to Sam's and Ellen's question, another way that we can think about it is that what's happening between police and people is public, right? It's happening because they're performing public work, they're enforcing a public law, and the resolution of the problems that come out of those interactions, I think, should also often be public, right? So if you have a public person performing a public job who is wronged by doing that public thing, their solution should also be public. Does that make sense?
Yeah,
because,
I mean, yeah, go, you finish, and I'll come back once you're done.
Yeah, and it doesn't work this. So when you're a private citizen, you're having that public interaction, but you're not a servant of the public, right? You're just you are the public, and so there isn't asymmetry in both of your positionalities. And so I think I'm more comfortable with a system in which the person who is a public representative is compensated from the public purse for things that befall them while performing that job, as opposed to turning to private law for remedy.
Okay, so the claim then is, even if there were such a thing as a successful claim in that in the sort of private law realm for something like a slur, do you see then that workers' compensation as one of your solutions falling within the public side of that divide?
I think it can, and workers' compensation is not perfect, right? And I think I would not be immediately adverse to making that system better, because as I hope I indicated in my response to Ellie, it is people like the officer who was shot and killed at Temple for nothing, like that. I obviously think that his family should be compensated for the loss of him. That's a terrible thing that happened. Do I think that suing that person's family is going to make anything about that situation better? I don't, right? I think that the family should get compensated. I think, or the officer's family should get compensated. I think that the shooter is being dealt with within the criminal justice system, and I'm not sure that we gain a lot by suing his family for that harm.
Hey, thank you. I cut in on Professor Zoe Sinnell, and then Ellen and Sam both have follow-up questions that we can circle back on.
Great. So I was writing things out. I thought I had one question, but it looks like I have 4. So I'm really sorry. It might just be like three comments and half a question. So I think this is great. So we all, like most of what I read, we're all focusing on like public authority liability. And so you have the English who are like, well, you can't have any liability that's outside what a regular person would have. Therefore, public authorities aren't liable for things like that horrible Michael's case where, she called for help to the police, and then they're like, stay in place, don't worry, we're right there. And then they misclassified the call, and then her her boyfriend came back and killed her, right? Like, oh, sorry, because an ordinary person wouldn't be liable in that case. So neither the police. So it's nice to have this sort of reframing of it. So I guess this kind of gets at the same kind of question, though, is to what extent are public authorities treated just as persons, right? People. And to what extent are they treated as public authorities? And so I think in the case of the first situation, when a public authority is, I think, kind of unpopularly among some of my friends, but I think that there's a way in which when a public authority holds itself out as providing it's different from a person. It's not just a person. It stands in a different relationship to, the people that it is there to protect or provide services for than a regular person would be. It's not about reliance, and not about, you can move it. So I think, but in this case, I worry that police officers are being treated as public authorities when they are actually also equally persons. So, so my sense is that more is going on here than just harm. People might be surprised about this, right? So the fact that, you said the heart of the paper is these lawsuits do more harm, right? And maybe they do. And I'm like, I don't care, right? I mean, part of me cares. I care about harm. I guess it's bad. Although I just written a paper where I'm like, it's not actually bad. But right. But so I care about wrongs. And so if someone is wronged, a police officer has been wronged, then they ought to be able to have their day in court or able to be to have some civil recourse. So I want to sort of push now on Sam's point. I think that got kind of lost at the end there. Sam's like, well, what about self-defense? And so the word, so if because I think your argument could be almost the point where, like, if there's no wrong here, if they haven't been wrong because they're public authorities, not persons in this way, then they couldn't actually resist violence with violence, right? They couldn't protect themselves, and they would have an obligation which other people don't have, which is to like walk away, which you don't have in the doctrine of self-defense. You don't have to. You can stay put, and you're allowed to fight. That's part of what it is. And so I worry that, so then I'm like, okay, but if you think that self-defense actually is, police officers can defend themselves, which I think you do, right? Then we're taking away, actually, we're expropriating in some ways their right of civil recourse. And so that treats them really differently from other persons. And I'm just a little worried because I think this is a battery. So I think you're like on firmer ground when you're talking about these professional rescue situations. So my first question, because I know nothing about this doctrine, my first thing, like, danger invites rescue, right? Like, I remember this line from first year torts. But then I'm like, okay, I guess in this case, you say, like, so some sort of voluntary assumption of risk that's associated with doing a particular job. So there's some things, like, you're a hockey player, you agree to getting your teeth knocked out. Like, that's kind of part of like what it is. With a police officer, you agree to going into a home and like slipping and falling on some water, right? Because you're rescuing people. But I do worry, right? I'm worried that now police officers are treated, despite the fact they might have, perhaps, potentially, it's an empirical question, more power in some ways than those they police, right? They're being treated not as persons anymore, but just as, say, arms of the state, in a way that I'm not, as kind of a rights-based person, I'm like a little uncomfortable with. So anyway, I just love to hear your thoughts. I'm not sure there's actually any question there, so now I apologize. I promised you 4. I gave you like a quarter of one, but I actually just gave you Sam's question again, so I cheated. It was even worse. But thanks so much. I found this really fascinating.
Like, okay, so for I'll start here. I think one of the interesting things that happens in this area is that police move between a public and a private person, right? And so they're public for a lot of purposes, but they are also private we're sort of seen, or well, are they still private for the civil recourse purpose? So it just came to mind. I don't think I mentioned in this paper. Another important thing to know about the asymmetries, right, is even in the rare cases where police are liable, they don't pay. Okay, they virtually never pay. The person that pays is the city, right? So even if that's just another way.
But most tort defendants don't pay either. Like, their insurer pays. That's not a problem, right? Like, because they pay on behalf of, and so there's like a way to get around that. Like, but yeah, just
in these instances, though, right? So I think that most people are focused on the intentional issue. So the negligent and the homeowner's insurance gets a little bit complicated because the majority of states do have that professional rescuers doctrine, right? And so if it's a straight out negligence case, you're not going to be able to bring it, right? And so you're not going to access homeowner's insurance, because if it's a puddle slip case, you don't have liability, right? An insurer is going to know that. And so you're not going to get money from home insurers for that. So really your best bet. But again, I have the negligent intentional tort line, I argue, is also inherently slip. Basically, anytime we try to pull a binary, it's slippery, right? Anytime we try to say, oh, it's public, now it's private, it's fuzzy. Anytime we want to try to say it's negligent or it's intentional, it's also fuzzy. The argument is really one of public policy, right? And it's really saying, most of my scholarship, and this is where we get into the sort of political consequences. I mean, most of my scholarship is arguing for litigation expansions, right? I'm not making this argument flippantly or lightly. I think I would need a really serious justification to limit litigation. I love litigation. I practice litigation. I think it has really important social equality purposes that I argue in multiple pieces why we should have more litigation. And so I really take seriously that if we're going to limit it, we need to have really good reasons for doing that. And I think we have them here. I actually think that this is probably one of the easiest arguments for limitations because of these really significant policy or political harms. We can see in the sociological literature what happens when we have these kinds of litigative claims brought, and we can readily achieve what we're trying to achieve through civil litigation. We can achieve compensation, we can achieve deterrence through other means in this context. So I think that that's really important. I do, so, and in terms of assumption of risk, as Ellie talks about in one of her pieces, and maybe she'll fill in some of the blanks here. So that this actually happened in the McKesson case, right? Which I'm not sure we've heard the last word on that, but the Louisiana Supreme Court said we have a case where we say we don't do assumption of risk anymore. That's not a thing. And because we don't do that, implicitly, that means we don't have the professional rescuer doctrine rule anymore. But I'm not sure assumption of risk is really the best grounding for the professional rescuer rule. I think we can have it for other public policy reasons, like the harms that I talk about in the paper.
Okay, so yeah, Zoe, maybe we'll just get the last two.
Yeah,
Why don't
that's
we
what I
do
was
the
gonna
thing?
say.
Yeah, it's just to get all the feedback on the table. Why don't we do the thing? So Ellen, maybe you can ask your questions, and then Sam as well, and then Sarah can have a chance to respond to them together.
I guess my questions are actually follow-ups to Sam's and Zoe's, and the first is really, you were talking about the inequality of people not being able to sue the police as easily, and so therefore police should be restricted. But why don't you come out the other way and just say that both ought to be allowed? And it seems to me what you're arguing for, to not allow police, has a certain political valence to that limitation. And then the second thing, Zoe, Michael is actionable in Arizona, and there is actually quite a bit of liability, I think, of police. And Sarah, you and I can talk about a lot of payments, but also even in cases, and Michael is one of them. We have a straight on similar case. But I think in terms of Zoe's question, it seems to me you're saying, you put on that uniform, you're in a public job, you get what you get, don't ask for anything, don't ask for any rights. And, even Times versus Sullivan, they say this is defamation liability is really restricted, but it could be in a little case. And, to me, that's less than the interest in physical liability. And do you have any limits? Like, is there any place where when you put on that uniform, people still owe any consideration to you in terms of your interest as a person?
Just want to be clear, it's not that you don't, people owe considerations, and we can see this in the criminal law, right? That's why we have these huge criminal penalties. If you mess with police officers, you're going to have a significant mandatory punishment imposed on you. So it's not just, it's a free for all and they have to take their lumps and it's open season on police officers. We have our biggest deterrent tool is criminal law, right? And we use it unabashedly. And I am not taking issue with doing that. What I am taking issue with is bringing in civil litigation where it doesn't do much and it creates all of these sorts of harms. But I do have an exception. So you might like this one. So I do think that for products liability, it doesn't implicate any of these sort of democratic or political harms. And so if, for instance, you wear a vest and that vest is supposed to protect you in certain ways and it does not do that, I absolutely think that police officers should be able to sue for that. I think if they use firearms that turn out to be defective, they should absolutely be able to sue for that. And they still have, I think, there's tons of suits against employers, fine, right? It doesn't impact, it doesn't have these political democratic consequences, fine, sue your employer, great. Sue for non-police related things, also great. But just in this one context where you are enforcing, you already have all of the powers we can possibly empower someone with, really powers of life and death. And to say that, and you can also sue people, even though we know that there are ways that these existing powers are abused, we're going to give you more, right? And I think at some point we have to rebalance that scale.
And so Sam.
Yeah, thanks. Yeah, I mean, unsurprisingly, just because we've been building on each other, right? I share Alan's sentiment. I would push you in the other direction and say the problem is the protections, not the fact that the police can sue. And I worry that by pointing to, yeah, we have criminal law to deter, we have workers' compensation to compensate. It's not really worth suing people who don't have a lot of money. What you're doing is just making an argument against tort liability altogether for personal injuries. I mean, if one of my students is unhappy with their grade and they shoot me in the classroom, I get workers' comp from my employer, I assume, or I get workers' comp rather. That protects my employer actually, because it protects my employer from getting sued by me rather than I get the guaranteed compensation. But that's got nothing to do with my right to sue the student who shoots me. And it seems like there's an equivalent argument to be made there for the police if we want to treat the police like they are people with rights of action or people with, dignity that they are also able to access civil justice in respect of. But I completely agree. If it has to go both ways. They are also people who can cause harms to other people, and so they should be able to be sued in the same way as other people there. So yeah, I guess my concern is that you might be doing too much by pointing to those things, because those are just the same arguments that get made for replacing tort law with a no-fault compensation scheme altogether.
Yeah, I mean, but that sort of is the argument I'm making in this specific context, right? So I'm saying that it's really an argument that almost everything is different in the police context. And we accept that when they're defendants, that it's supposed to be different and they're supposed to have all of these different things attached. And so then we see them as public when they're defendants, right? But then they slip back into this, I'm just, an average person who's been harmed for the purposes of that civil litigation suit. And I think it would make more sense as a public policy matter to just have equity across the board, I think, right? And so it sounds like what you're most interested in, if I'm understanding your question correctly, is the reason why you would want to sue the student is for the expressive component, right?
Well,
is that right? Is that what you think you're getting from
the student has wronged me, right? There's all sorts of reasons people sue, right? I teach lots of cases in tort where people are suing for very small amounts of damages, but because it's a matter of principle, their rights have been violated. Maybe I want to deter my students from shooting me. Workers' compensation isn't going to deter my students from shooting me. So there are those arguments, but I guess, I mean, I guess I'm just reiterating the point, though. My inclination would be to come out the other way and say, I mean, I accept all the political issues, and so maybe that is a strong enough argument for this, but I don't think criminal law deterrence and workers' compensation and all of these things are good arguments in this context, because they're the same arguments in the private context. And the real problem here is we have inequality of arms and inequality of doctrine, because it doesn't flip the other way. Which means the real problem is we should get rid of the qualified immunity and the statutory immunities for officers, not take away their rights just because they've put on a uniform.
Yeah, I guess I'm not sure in this context. So it sounds like you are advocating for a world that is full of litigation.
I'm advocating for a world like Canada or England or Australia, where a police officer wrongs you, you actually can sue them and get substantive damages against them. And there's no such thing where courts will say an officer is to be treated as in the same way as an ordinary person, and they have no qualified immunity. And I can, if you're interested, I can send you an excellent article on that subject.
Yeah. Great, thank you. Yeah, I mean, honestly, it's hard to imagine that world from down here.
That article is written by him. I just want you to know.
Oh, perfect.
I can tell you, come up in person sometime. Excellent. We can show you that world.
Absolutely. I love it. Yeah, but so for this one, I mean, I don't take it lightly. I don't argue willy-nilly that we should contract litigation. But I think here, given those asymmetries, those power imbalances, and just that democratic harm, that the political harm of not being able to have the kinds of communities that we want to have, it makes sense to make that limitation in this particular context.
Okay, thank you so much, Professor Swan. It's been an excellent discussion. I think it continues in the future. So let's all use the various virtual functions to
Thanks very much.
you.
Excellent. Thanks so much. I'll be posting the paper to SSRN in the next couple of weeks, but if you're interested, that has its own quirks. So if you are interested in reading it, just email me. I'm easy to find online, and I'm more than happy to send out a copy. Thanks.
I'm going to say hopefully this forum leads to some positive feedback for the final publication. And I guess we'll see everybody next month for the next iteration of the speaker series. Thanks for coming out.
Thank you.
Bye-bye. Thank you so much, Sarah. That was awesome. And so, like I said, if you have any other sort of questions that I can send the paper to Sophia, like you mentioned, I'm happy to do that. I hope you found it helpful.
Excellent. Absolutely. That was great. Thank you so much.
Enjoy your trip to Quebec. Bye-bye.
Thanks.